Representative O'Neill of the 69th District, the floor is yours, sir.
Thank you, Mr. Speaker. I will try not to be too repetitive. It's going to be difficult because the ranking member has done such a comprehensive and masterful presentation of the concerns and issues that those of us on the Judiciary Committee who voted no entertained, and things that we were concerned about. But I will just repeat briefly, the Chief Justice is a lot more than the person who calls the court to order when they sit down to make decisions or hear our oral argument. The Chief Justice appoints the Chief Court Administrator. And the Chief Court Administrator really acts as the manager and budget director of the judicial branch. Together with the Chief Justice, the Chief Court Administrator prepares the budget for the branch. In other words, no other judge votes on whether the budget's going to go up or down or how the money is going to be spent. The nominee before us, Associate Justice McDonald, acknowledged as much by indicating that he really had no actual knowledge of how the budget was prepared, and he received only the briefest of briefings before the budget was sent over to the legislature by the judicial branch. In March of 2013, I voted as a member of the Judiciary Committee and then later as a member of this body to confirm Andrew McDonald as an Associate Justice of the Connecticut Supreme Court. I did so after questioning him on a number of issues about which I was concerned, which included his professional, political, and personal relationship to Governor Malloy. Here are some of the pertinent parts of the transcript of that March 2013 hearing. We had had an earlier judge had a hearing, and he had responded to issues relating to recusal. That is, when a judge disqualifies himself from sitting on a case. O'Neill. Judge Grundle's answer was, a judge should disqualify himself or herself in any case where the judge has strong personal relation with one of the parties or attorneys, or where the judge's personal views will interfere with the judge's ability to decide the case fairly. Is that approximately the view that you take based on what you remember that you wrote in your questionnaire? Answer from Andrew McDonald. It is. He agreed with what Judge Grundle said. It also, he went on to say, requires that you recuse yourself if it can reasonably be inferred that you have a bias. Okay, I said. You described the role of legal counsel to the governor. Quote, in my current position, I serve as chief legal advisor to the governor, the lieutenant governor, and their respective senior staffs. I provide legal advice, counsel, and analysis to the governor on all aspects of executive branch functions and operations. I oversee all in-house legal functions, including supervising 85 attorneys in various departments of the state. I review and analyze all public acts and make recommendations concerning soundness and whether the legislation should be vetoed. I negotiate legislation, issues, and policy matters on behalf of the governor and represent him in a variety of forums. Representative O'Neill. Okay, with respect to the disqualification issue, for example, if someone brings suit and names the governor as a defendant, is that, without having to really look at it any further, going to be something that if it shows up in the Supreme Court, that's something you feel you should likely disqualify yourself from? Answer. It certainly would depend on, it has been said before, every case has to be analyzed on the facts of the case. If the governor is nominally named, and just because there has to be a name on the pleadings, I would analyze that. If there's anything that relates to the governor personally, he's not only a client, but a close personal friend of mine, and I would absolutely recuse myself. Representative O'Neill. So your relationship with Governor Malloy has been personal enough so that he would qualify as the kind of personal relationship that would disqualify if named personally in matters. Andrew McDonald, yes. Representative O'Neill, okay. Because it would seem to me that for the circumstances of having been such a close advisor to the governor and involved in all these things, it certainly is a reasonable default position to take, certainly as long as Governor Malloy is in office, or any of these matters that you personally worked on are coming up, that a disqualification might be the safest course of action in a lot of these cases, just to avoid the sense that somehow the governor has one vote that he can count on because you worked on it, or he talked about it, or something like that. Answer from Andrew McDonald: I absolutely agree. I voted to confirm Andrew McDonald as an Associate Justice of the Supreme Court, even though I had serious concerns about the fact that he had no prior judicial record. This was only the third time in the history of the state of Connecticut that we know of where someone is appointed and confirmed to be on the Supreme Court without previously having served as a judge of the Superior Court or some other court. We had no record of his conduct as a judge. We had to rely entirely on his representations at the public hearing regarding such issues as recusal. On February 26th, I voted against confirmation of Andrew McDonald as Chief Justice of the Connecticut Supreme Court. Why? Because I believe that Associate Justice McDonald has failed to live up to his commitment to recuse himself in cases involving Governor Malloy, where recusal is justified, to avoid a reasonable inference of bias. He acknowledged that he is a close personal friend of Governor Malloy, and because of that personal friendship, he would err on the side of caution to avoid the appearance that Governor Malloy had, as I phrased it, one vote he could count on in the Supreme Court. The crucial cases are the death penalty cases of Santiago and Peeler, in which the question of the effect of the prospective repeal of the death penalty was decided. On July 10, 2014, a little over a year after being confirmed as a Justice of the Supreme Court, Associate Justice McDonald participated in the Santiago case, as you've heard. On August 25, 2015, Justice McDonald cast the deciding vote that overturned the death penalty on constitutional grounds. He reaffirmed that decision in the Peeler case on January 7, 2016. In his public hearing this year, he claimed he had no involvement in negotiating, reading the bill, or advising the governor about signing or vetoing Public Act 12-5, which was the law that was the basis of overturning the death penalty in Santiago. Now, back in 2013, in answers to some of the questions that I put to him, he stated, I am very involved in matters that are likely to develop into significant public policy matters for the administration. This year, he claimed that he seldom, if ever, advised the governor about the constitutionality of the laws the legislature passed, indicating that constitutionality of laws and legislation is not something he concerned himself either as lawyer for the governor or as a legislator. That was up to the courts to decide. When Representative, who just spoke, the ranking member of the Judiciary Committee, asked him about those newspaper articles describing, where he is quoted describing constitutional problems, and she just quoted them. Associate Justice McDonald, in our hearing just a few weeks ago, sounding sort of like a character out of Mission Impossible, denied all knowledge of those quotes and insisted that the legislation that the quotes related to did not pass the Assembly while he was lawyer for the governor, that that law only passed after he left the governor's office. When I specifically asked about recusal in Santiago, Associate Justice McDonald claimed he was required by the Code of Judicial Conduct to sit on the case and not recuse himself, although he acknowledged that there is absolutely no Connecticut precedent saying that that was so. Now, his defenders on the Judiciary Committee pointed out to cases such as one involving former Chief Justice of the United States Supreme Court Rehnquist and former U.S. Supreme Court Justice Scalia in their decisions not to recuse themselves in some extremely controversial cases. Neither the Rehnquist case nor the Scalia case should be considered as applicable or supportive of Justice McDonald's decision. In Rehnquist, the facts of the situation were as follows. Rehnquist, while working as an attorney for the U.S. Justice Department, testified in front of the Senate committee, chaired by Senator Sam Ervin, that was investigating the activities of the Lyndon Johnson administration, whereby they were spying on Americans protesting the Vietnam War, gathering data, taking pictures, and creating computerized dossiers. Justice Rehnquist, in his testimony, said he didn't think what the U.S. Army did was unconstitutional or even illegal. And he referenced a case, Laird v. Tatum, when he was testifying. Not long after that testimony, he was appointed to be a Justice of the United States Supreme Court, and the Laird v. Tatum case was presented to the United States Supreme Court for his consideration. He was asked to recuse himself on the grounds that he had already prejudged the key issue in the case. Justice Rehnquist responded by denying the motion and filing an 8-page-long memorandum in support of his own decision. In that memorandum, Mr. Justice Rehnquist stated, quote, "Based on the foregoing analysis, I conclude that the applicable statute does not warrant my disqualification in this case. Having so said, I would certainly concede that fair-minded judges might disagree about this matter. If all doubts were resolved in favor of disqualification, it may be that I should disqualify myself simply because I do regard the question as a fairly debatable one, even though upon analysis I would resolve in favor of sitting." Now, the interesting thing about this memorandum is that there was an earlier draft, and in Justice Rehnquist's papers that were released after his death in 2008, a copy of that earlier draft was released. And in that earlier draft is a line that didn't find its way into the final memorandum that said, "This is an extremely close case." The other thing worth noting about the Rehnquist case that was cited during the hearing on Justice McDonald is that shortly after Rehnquist issued his memorandum and decided to sit on the case, the Congress of the United States changed the federal statute governing judicial disqualifications. And Justice Rehnquist, in his Chief Justice hearing in front of the United States Senate in 1986 acknowledged that those changes, had they been in the law at the time of the Laird case, would have required him to disqualify himself. So I don't see the Rehnquist case as really supporting, in a situation such as this, you've got to just sit on these cases. Certainly not if you've already acknowledged you shouldn't sit on any of the cases where there's any doubt, where there's any reasonable inference that you might be biased. The second case that was brought up was a case involving Justice Scalia, in which he had gone on a hunting trip with then Vice President Cheney, and then a case involving Vice President Cheney was brought to the Supreme Court, and he was asked to disqualify himself because of the hunting trip, because he had had a long association dating back to when they both worked in the Ford presidency White House. And Justice Scalia responded as follows: "Let me respond at the outset to the Sierra Club's suggestion that I should resolve any doubts in favor of recusal. That might be sound advice if I were sitting on a court of appeals. There, my place would be taken by another judge, and the case would be able to proceed normally. On the Supreme Court, however, there's the U.S. Supreme Court, the consequence is different. If the court proceeds with 8 justices, raising the possibility that by reason of a tie vote, it will be unable to resolve significant legal issues." Now, the situation here in Connecticut, and I went over this with Mr. Justice McDonald, is very similar on our Supreme Court to a federal appeals court. If one of the justices of our Supreme Court disqualifies himself, his place can be taken by someone brought up from the appellate court. A senior appellate court judge can sit. And in fact, that is exactly what happened when Justice McDonald recused himself in the CCJEF versus Rell case, the one involving the school funding that was just decided very recently. Another judge was brought in to sit in place of Justice McDonald. So the compelling reason in the Scalia case that was cited as the justification for Justice McDonald's sitting on Santiago and Peeler doesn't exist. Under Connecticut law, we can bring in a replacement justice. It's not the same kind of problem as exists at the federal level. And Scalia's entire decision to remain on the case involving Vice President Cheney was based on the idea that he was basically an indispensable justice to hear that case. He could not be replaced. Now, there is another case involving recusal that is worth noting, and that is the case of Caperton versus the A.G. Massey Coal Company. In that case, a justice of the West Virginia Supreme Court was elected. He was elected with $3 million worth of campaign contributions donated to him by one of the owners of the A.J. Massey Coal Company. He then sat on an appeal that was pending during the election campaign. He was asked to disqualify himself. He said no. The case went up to the United States Supreme Court, 2008. And in that case, the United States Supreme Court ruled that the question is whether, under a realistic appraisal of psychological tendencies and human weaknesses, The interest of a judge poses such a risk of actual bias or prejudgment that the practice must be forbidden if the guarantee of due process is to be adequately implemented. This has been an evolving standard. We go back to the Toomey case, 1920s, when judges' salaries were paid out of the fines that were assessed against the people they convicted. And in 1927, the United States Supreme Court ruled, that's unconstitutional. You can't have the judge getting paid out of the fines and think you're going to get fair judgments in criminal cases. And over the years, there's been a gradual evolution of the constitutional standard in this country about where disqualification is required. And bear in mind, the constitutional standard for disqualification of judges is the rock-bottom bare minimum. The courts over and over again refer to the fact that most states have laws or rules that require even more stringency than what the due process clause of the Constitution requires. There's a recent law review article that reviewed the Caperton case and the evolution of this standard. And in that article, it is stated, the Supreme Court has gradually expanded the common law rule over the last century to require recusal based on due process in new situations. So this is where we're going as a state. When in doubt, a judge should recuse himself. Interestingly enough, and somewhat ironically, like so many things about this situation, that law review article was published by Cornell University. Now, Justice McDonald indicated that there have never been any cases where, in his kind of situation, because of a personal relationship, a judge has been found to need to recuse themselves. And I would point out that in 1977, in the state of Alabama, George Wallace was going through a divorce, and the judge whom he had appointed to the judgeship was hearing the case. And that judge's father was one of Governor Wallace's strong supporters and friends. And not surprisingly, Mrs. Wallace requested a recusal. The judge refused. But in Alabama, because this was a trial court, and because there was a higher court that could hear the appeal, that judge was required to recuse himself and step away from the case. So personal relationships with the appointing authority can be and have been the basis of recusal. This is not some novel, we just made it up this year standard. This has been going on in this country. We've been gradually moving in this direction. Even the United States Supreme Court, as a matter of constitutional law, of due process, has held that you've got to make sure that there is not this potential for bias in order to ensure the credibility and the integrity of the judicial system. Simply put, we cannot trust Associate Justice McDonald to make the right decisions when it comes to recusal in cases involving policies formulated during Governor Malloy's administration. Now, it is very unlikely that the United States Supreme Court will ever review a disqualification case involving Justice McDonald. Those cases that I cited to you happen, such as Caperton or Toomey, about once every 30 or so years. The Supreme Court hears very few cases out of the thousands and thousands of writs of certiorari that are filed. They hear a few hundred. So it is really up to us to make the decision here today as to whether or not we think the conduct of Connecticut judges should be governed more stringently than it has been. There is no one to whom you can appeal if you're a litigant and you feel that Justice McDonald should have recused himself, other than the U.S. Supreme Court. There's no court of review. There's no one else to ask who could sit and say, Justice McDonald should be recused. Not the governor, not this legislature. Once Justice McDonald is confirmed as Chief Justice, he will be the ultimate authority within the judicial branch on the Supreme Court, and he alone will decide whether or not he recuses himself from these kinds of cases in the future. It is our duty to hold Justice McDonald accountable. There is no one else. There is no other time. I believe I am quoting Hillel. If not us, who? If not now, when? Please vote no on this nomination.